Thanks for attending our webinar tonight on customs regulation of offshore oil and gas installations. Our presenter tonight is Mikhail Kashubsky. He's a senior lecturer at the Centre for Customs and Excise Studies. He is also the head of secretariat of the International Network of Customs Universities. He is a graduate of the University of Canberra and a qualified Australian lawyer. Mikhail teaches several subjects at the University of Canberra, including international commercial transactions law, international supply chain management and transnational crime. His research interests include international trade law, customs law, offshore oil and gas law, maritime security law and marine environment pollution law. He has also written publications on these topics. And I'll hand you over to him now to begin his presentation.
In the last decade, the offshore petroleum industry has become of critical importance to the global economy. There is the increasing demand for energy resources, and combined together with major technological advances, that there has been a shift of petroleum operations from land to offshore locations, and states and oil corporations are turning their attention to the sea for offshore petroleum resources more than ever before. Currently, approximately 30% of the total global petroleum production comes from the offshore petroleum sector, and this figure is expected to increase significantly due to depleting onshore fields and rapidly expanding offshore petroleum exploration and exploitation. So the offshore platforms have become a common feature of many continental shelf areas in the world, and these platforms are considered to be elements of critical national infrastructure in many states, which has significant implications for national security and economy. And on this slide, these are just some of the examples of offshore platform. On the left-hand side, we have some production platforms, and on the right-hand side it's a drilling platform. But you can see from the pictures that they're very complex structures. On this slide, this diagram also shows you different types of offshore platforms. For example, we have the mobile platforms, which can be moved from one location to another. And in the middle, we have the fixed configuration platforms, such as the jacket structures and gravity-based structures, which are the more common ones. So, and customs, they also need to be familiar with the different types of offshore platforms. And this is actually one of the issues that when customs officers go on board of these platforms, they're very unknown to them, and makes any customs operations very difficult. For example, like searching the platform, ensuring that it is compliant with some security-related requirements. So the big question is, what is the role of customs in regulating offshore oil and gas installations, or the offshore petroleum industry in general? And in some countries, customs does not have any roles or responsibilities with regard to offshore installations. In other countries, customs administrations have a range of responsibilities with respect to offshore oil and gas installations, and such as in Australia. And in Australia, offshore platforms fall under control of customs. So with the increasing number of these platforms, their regulation is becoming a new area of responsibility for some customs administrations. And for those customs administrations that already have responsibilities with regard to the offshore industry, they may find that they would have to devote more attention or spend more resources on controlling and regulating activities with respect to oil and gas installations. So some of the issues that are relevant to customs, for example, customs may be involved in the regulation of attachment or emplacement of a platform to the seabed, or it may have an interest in import or export of petroleum installations. There are also ships coming and going to and from platforms, as well as people, and goods and stores are brought on board and sometimes taken off board. So these are the types of areas that customs may have interest in. More recently, security has become a significant area where customs administrations or customs authorities may be providing some protection to offshore oil and gas installations, including surveillance and security patrols around offshore platforms. So customs can exercise control over offshore installations and to ensure compliance with relevant customs laws and regulations. In Australia, the Customs Act contains a number of specific provisions in relation to platforms located in the Australia's exclusive economic zone or on the continental shelf area of Australia. And we will look at these legislative provisions later in this webinar. But before that, I would like to talk to you about customs jurisdiction in both international law and Australian law. In international law, the United Nations Convention on the Law of the Sea provides the basis for customs jurisdiction with regard to offshore platforms. The Law of the Sea Convention established new maritime zones of jurisdiction and granted coastal states exclusive jurisdiction over offshore oil and gas installations in the exclusive economic zone and on the continental shelf, including jurisdiction with respect to customs laws and regulations. So this in turn created new responsibilities for customs administrations of some coastal states in regulating certain aspects of the offshore petroleum industry in the areas that are far offshore. On this slide just shows the different maritime zones of jurisdiction. So with the adoption and coming into force of the Law of the Sea Convention, coastal states are now able to claim the exclusive economic zone, extending to 200 nautical miles from their territorial sea, and also they're able to claim the continental shelf areas to a maximum distance of 350 nautical miles. So on this diagram, you can see this is the legal continental shelf area, and this here is a 12-mile territorial sea of a state. So on the continental shelf, where most of the offshore platforms are located, coastal states enjoy sovereign rights to exploit oil and gas resources of the seabed, and many states do. So there is no doubt that customs laws and regulations of the coastal states will be applied with respect to oil rigs. In the internal waters and in the territorial sea, this will be on the basis of state sovereignty over those areas of the sea, because up to the 12 nautical miles there is coastal state sovereignty in that area. In the exclusive economic zone and on the continental shelf, up to 200 nautical miles, Article 60 is the relevant provision of the Law of the Sea Convention, and it says that the coastal state has exclusive jurisdiction over offshore oil and gas installations, including jurisdiction with respect to customs, fiscal, health, safety, and immigration laws and regulations. So the Law of the Sea Convention clearly gives the coastal states jurisdiction with respect to customs, and I've highlighted the word customs there in blue. In case when a non-coastal state establishes an offshore installation on the continental shelf of or in the EEZ with the authorization of the coastal state, the coastal states will have jurisdiction with respect to customs matters, regardless of who owns the offshore installation. On the continental shelf beyond the 200 nautical miles, Article 80 of the Law of the Sea Convention provides that provisions of Article 60 relating to the EEZ apply to the continental shelf. So the coastal state has exclusive jurisdiction over offshore installations in that area as well with respect to customs matters. And international law is very clear in relation to jurisdiction, but it is not clear in relation to enforcement of interferences with offshore oil and gas installations generally, or something interferences with non-compliance with customs laws, for example, on board the platforms. So the enforcement against, especially against foreign ships, may be difficult sometimes. In Australia, the offshore jurisdiction of customs is sourced from Section 5129, the External Affairs part of the Constitution. Under that section, the Commonwealth of Australia has comprehensive authority to legislate for areas geographically external to Australia. And the Commonwealth the Australian government can also create offences, whether customs offences or other offences, applying outside the limits of the state, and can confer whatever powers it chooses in those areas, including the power to search, seizure, and arrest. So for purposes of ensuring better compliance with the customs laws, certain customs powers and enforcement measures extend to offshore areas. And the Customs Act applies to offshore petroleum installations that are deemed to be part of Australia, and if they are attached to the Australian seabed. So naturally, the Australian domestic law relating to customs, immigration, quarantine, or taxation, and security should apply to these offshore installations within Australian exclusive economic zone. In the next part of the presentation, we will look at the specific areas of regulation and Australian legislative provisions that address these aspects. So the first aspect is the attachment of installations to the seabed. And in Australia, the attachment of overseas offshore installations is controlled by customs. And the Customs Act prohibits persons to install or to attach offshore installations to the Australian seabed without obtaining a permit from customs. And customs may grant a permit or may impose certain conditions on the permit, such as the condition requiring a master or operator of the offshore installation to bring the installation to a specified place for examination for quarantine purposes. Customs can revoke or vary the permit or any condition imposed on the permit before an offshore installation is attached to the seabed. And an overseas offshore installation that becomes attached to the Australian seabed without the permission of customs may be forfeited to the government. So clearly the permission of customs is key when it comes to oil and gas industry. So the operation and use of offshore installations is also subject to the control of customs based on Section 33A of the Customs Act, which says that permission must be obtained from customs before an offshore installation can be used in activities associated with exploring and exploiting the Australian seabed. And customs may impose conditions on permit to operate an installation. The next area of that may be an interest for customs is import and export offshore installations. And particularly offshore drilling rigs, they are often brought from overseas to conduct offshore drilling operations on the coastal states' continental shelf. So some of the issues there are whether it is imported as an installation or whether it is imported as separate components and then assembled on site. Other issues are what tariff applies to or how should platform be classified, and that would depend on whether it is bought as a installation or whether it's just bought in different components and then assembled. Another issue is what is the customs duty that should be applied? Is it a temporary importation or permanent importation? And again, depending on the type of the installation, the answer to that question may be different. So in Australia, the Customs Act provides that where an overseas offshore installation becomes attached to the Australian seabed or is brought to a place in Australia, and is to be taken from that place into Australian waters for the purposes of being attached to the seabed, the installation and any goods on board that installation are deemed to have been imported in Australia. And the beneficial owner of the offshore installation becomes an importer for customs purposes at the time of importation. If the installation they owned was brought from overseas and then becomes attached to the seabed in Australia. So offshore petroleum installations may be subject to customs duties upon importation. In Australia, also for quarantine purposes, if the incoming offshore installation is cleared or haven't been quarantined and then cleared, it is granted a pratic, which means that it has a license in effect to enter the Australian jurisdiction. So, and then where an offshore installation ceases to be part of Australia, when it is detached from the seabed, the installation and any goods on the installation are deemed to have been exported from Australia at the time when the installation ceases to be part of Australia, or when it is detached from the seabed. This is the tariff classification that applies to offshore petroleum installations. They're classified as floating or submersible drilling or production platforms. And however, some offshore installations are very much look like ships. So again, depending on the nature of the installation, there may be some issues with classification. This is just a list of some of the other relevant tariff nomenclature that can apply to oil and gas industry. It mainly applies to different components used on board installations. The tariff classification and customs duty in Australia, and the Australian Customs Tariff Act 1995, Schedule 3 of the Act prescribes this classification. And in Australia, for those installations that do not exceed 150 gross tons, the customs duty is 5%, and for all other offshore installations, the customs duty is, there is no customs duty. So, but most of the installations, the vast majority, would come under that second category of other. So in effect, in Australia, there is no customs duty applied to importation of offshore petroleum installations. Some of the other areas of customs interest could be, in Australia, the Customs Act sets out the framework for customs regulation and control of movement of objects to and from installations, for example, people, ships, aircraft, goods, and we will not look at all of these detailed provisions here, so I'll just flick through those few slides. Okay, security in protection. In recent years, customs have become, in Australia, customs have become involved in security aspect, protecting offshore platforms from terrorism and other maritime crime. And customs does it in cooperation with Australian Navy. So in Australia, the Maritime Transport and Offshore Facilities Security Act, it has created additional powers which can be used by customs officers for the purposes of determining compliance with this Maritime Security Act, Maritime Transport and Offshore Facilities Security Act. And customs officers, they may be authorized to enter an offshore installation and inspect areas, observe the recording, record operating procedures, make photographs, check the security records, and authorized customs officers may also stop and search persons or vessels, and request persons to leave the areas in the vicinity of offshore installation, and remove persons from or vessels from offshore security zones. On this slide, you can see a picture of the Australian customs vessel near an offshore petroleum installation, which looks like floating storage and production platforms, which looks very similar to a ship, but it has production capability on board. So in Australia, the primary role for security falls on the entity called the Border Protection Command, which is a combination of customs, the Australian Navy, and a number of other government departments, but it is primarily well, it is only customs and the Navy that do the security type of work around offshore installations, like surveillance and patrolling, things like that. So security has added more responsibilities on Australian customs with regard to petroleum installations. In Australia, offshore petroleum installations are also subject to quarantine. And these are the provisions from the Quarantine Act that apply to offshore petroleum installations. And again, I will not be reading them out. You can have a read of them for yourself. The customs powers, the Customs Act, it has it lists a number of customs powers that customs officers have with regard to offshore petroleum installations. For example, power to board, power to search, power search installation and persons on board and their belongings, power to question those persons as to whether their identity. Sometimes there may need to be a detention of a person, so customs also has powers to detain and arrest. But it is important that these sort of powers are specifically spelled out in the legislation, specifically in the context of offshore oil and gas installations, because it may, if there are no explicit powers with regard to offshore petroleum installations, customs may have difficulty in enforcing or ensuring the compliance. So the key issue, in conclusion, I would like to say that the key issue is whether domestic legislation specifies jurisdiction and the role and responsibility of customs with respect to offshore oil and gas installations, and whether the legislation sets out the specific powers for customs officers. And I guess the other remaining questions is should customs have responsibilities with regard to offshore petroleum installations, or should it be an area of responsibility for someone else? And I strongly believe that customs should have responsibilities for this area or for this industry. And I think this presentation hopefully demonstrated how. Just in summary, just would like to provide a brief summary of what we discussed. We looked at the different types of offshore installations, and I highlighted the importance of the offshore oil and gas industry to the world and the global economy and security of many nation states. And we looked also at the role of customs and some of the specific areas of customs interest. We discussed jurisdiction of customs in Australian and international law, and then we looked at some of the specific areas of customs regulation. This area of customs regulation of oil and gas installations we cover in our unit called Regulation of Offshore Petroleum Installations, which can be taken as an elective in our Master of International Customs Law and Administration program. And this is just some of the topic, or all of the topics that are covered in that unit. And the customs regulation of oil and gas installations would probably be under topic 7, where we discuss the jurisdiction of offshore customs over offshore petroleum installations. I would like to thank you for your attention, and I am now happy to take any questions that you may have. Thank you.
That's great. Thanks, Mikhail. Another great presentation. We will just give you guys a few minutes just to type in your questions, should you have any. So I'll be muting us now, and I'll come back to you in just a moment. Hi there. Okay, we do have a very interesting question from Jiv. Okay, Jiv, I will read out your question. How do you determine what is the country of origin of petrol produced in an offshore installation for determining customs duties and import-export regulations? It may be easy in Australia, but imagine a case where an installation is 250 kilometres away from the coast of 2 or more countries. I'll hand it over to Mikhail.
Thank you, Ziv, for your question. Well, the country of origin would be the country that has the rights to that petroleum that was extracted from the seabed. So even if it's 250 kilometers away from a country, it would still be under the exclusive jurisdiction of that coastal state, because the coastal state jurisdiction over offshore oil and gas can extend up to, well, in the EEZ and the continental shelf, it can extend up to 200 miles offshore, but the continental shelf is also recognized. The extended continental shelf can be up to a distance of 350 nautical miles. So there will be a state that claims exclusive rights to that offshore oil and gas, and that state would be a state, the country of origin of petrol.
Right.
Of the raw material, not the petrol, the gas that we put in tanks, and petrol that we put at the gas stations, but the raw crude oil or natural gas extracted from the seabed.
Okay, thanks, Mikhail. I can see there are a number of questions coming in now, so please just give us a minute to sort through them. We'll be back with you in just a moment. Okay, well, the questions have certainly come flooding in. Okay, we will start with Gamini's. His question is, we talked about the goods that are imported for setting up the installation and the role of the customs regarding the classification and duties. How about the goods that are produced? How to take the quantities verified and collect any duties?
Thank you for this question. Well, there would on board offshore petroleum installations, there would be a meter, so the offshore oil and gas companies, that they are required to report how much oil and gas is extracted from the seabed. So part of that information can be used by customs. So if one government agency, for example in Australia it's Department of Energy and Resources, that has primary responsibility for oil and gas installations, if that department collects that information, it would pass it on to customs administrations. But I'm pretty sure that the arrangements with respect to oil and gas exports are slightly different, and the taxation system on imposing tax on petroleum produced is calculated in a different way, not like a normal customs duty. Thank you.
Okay, thanks, Mikhail. Okay, we do have time for just one more question tonight. So we'll take this one from Melissa. Her question is, normally something like an FPSO. Normally something like an FPSO is self-propelling as opposed to having to rely on another vessel to move. When something like that is entering the territorial waters of a country, will it normally be considered to be a goods importation, or will it be dealt with as a moving vessel?
Thank you, Melissa. It is very good and in a way difficult question, and the Customs Act in Australia does not address it, but for example, under the Maritime Transport and Offshore Facilities Securities Act that I mentioned in my webinar, an FPSO would be considered to be a ship while it is moving, but as soon as it becomes attached to the seabed, or when it's stopped and engaged in production operations, it is considered an offshore installation. And generally the same is under international law. With offshore installations that are of this sort of hybrid type, like sort of semi-ships and semi-platforms, this is a key issue, is whether they are ships or whether they are platforms. And one of the approaches that has been adopted is internationally is to treat them as ships when they're moving, and as platforms when they are on site engaged in offshore activities. So my best guess, and I don't know the exact answer, but my educated guess would be that it will be considered a ship when it is entering territorial sea of Australia.
Great. Okay, thank you, Mikhail. We will have to wrap it up there tonight. So I'd like to thank Mikhail for a very informative presentation, and thank you to everyone who has joined us tonight from around the world. I hope you enjoyed it and found it useful. Please take the time to complete the online survey that I'll be sending you out tomorrow, as we do strongly value your opinion. As Mikhail mentioned in his presentation, these courses are available as part of our postgraduate program and also as a vocational course for our government agencies and private industry. If your organisation is interested in a tailored course, then please send me an email with your inquiries so that we can start discussions on this. Here at CCES, we're always willing to discuss opportunities and to tailor programs to meet needs of your organisations. Thanks again for attending our webinar tonight. We do only have a few free webinars to go until the end of the year. The next one is on maritime enforcement. That will be in 2 weeks from now on the 14th of November, again at 6 p.m. Australian Eastern Daylight Savings Time, which is GMT plus 10, and that will be presented by Adjunct Associate Professor Andy Johnson. Thank you very much, and I'll be closing the webinar now.